Hello and welcome to Head Start for Unit 3 from the Victoria Law Foundation. My name is Jane Patrick and I'm talking to you because of my experience in the law, I guess, is the reason I'm talking to you about this. I used to be a magistrate. I was a magistrate for 8 years and then I was a county court judge for 10 years. So I'm going to be talking to you about some of the things that you'll be studying in Unit 3 when you start next year. First, I'd like to say that I think it's fantastic that so many of you are studying Unit 3 and hopefully Unit 4 of legal studies, because it's a wonderful course that teaches you a lot about how our society operates and how the legal system operates. And it's really good that so many students are doing that. At the start of the year, you'll start off with an overview of some of the principles that you looked at before in Units 1 and 2, such as the principles of justice. You already be familiar with these principles of justice, fairness, equality, and access. And you will have already been thinking a bit about whether those principles are incorporated in various areas of the law and how they actually operate in practice. You will be aware of the distinction between civil and criminal jurisdictions. You'll know that criminal jurisdiction is where the jurisdiction in which people are prosecuted by the state on behalf of the community for having committed offences or being alleged to have committed offences against various statutes, legislation, or indeed against the common law where there are common law offences. You'll start the year off looking at the criminal justice system, and later in the year you'll do the civil justice system. So I'm going to be talking to you about the criminal justice system. There are three key concepts in the criminal justice system that are really important. These are the presumption of innocence, the burden of proof, and the standard of proof. There are a number of concepts which operate throughout both criminal and civil systems to make sure that hearings are fair and so forth. But these three key concepts, which are interrelated, the presumption of innocence, the burden of proof, and the standard of proof, are very important concepts in the criminal justice system. And they operate every day in our courts, in the magistrates' court dealing with crime. So the magistrates have to bear in mind these principles, and so do the prosecutors. And in the county court, judges, juries, prosecutors, and defence have to also bear all of these presumptions in mind. Now, all these concepts in mind, I should say. The three concepts are interconnected. So the accused person is presumed innocent of the crime with which they are charged unless the prosecution has proved the accused guilty according to law. So it is the prosecution, that's the police in the magistrates' court, it's the Office of Public Prosecutions in the county court and in the Supreme Court. The prosecution has the burden or onus, the responsibility of proving the guilt of the accused. The prosecution has to bring forward the evidence. The prosecution has to prove the accused's guilt to a high standard. The prosecution has to prove the accused's guilt beyond reasonable doubt. Now, that's the standard of proof that operates in the criminal justice system, beyond reasonable doubt. There is a different and lower standard of proof that operates in the civil system, which is on a balance of probabilities. So, for example, if a person says, I paid Mr. Bloggs $10,000 for his second-hand car, and Mr. Bloggs never gave me the car, then that person will go to court and sue Mr. Bloggs for breach of contract. In that case, the plaintiff, the person who goes to court, has to prove the case on a balance of probabilities. Is it more probable than not that Mr. Bloggs didn't deliver the car, having been paid the $10,000? Is it more probable than not that Mr. Bloggs was in breach of the contract? In the criminal justice system, the standard of proof is different and higher, beyond reasonable doubt. It used to be that judges couldn't explain anything about what beyond reasonable doubt meant, but nowadays there's new legislation, new acts passed by Parliament or fairly recent, which makes it a bit easier, and the judges are allowed to say something to juries about what beyond reasonable doubt might mean, such as that it doesn't have to be proved to 100%, it is beyond reasonable doubt, things like that, various concepts, which are quite interesting to look at, but I won't take your time up with those now. Now, it is really important to remember that these key concepts are the foundations of rights for the accused, such as the right to remain silent. The accused is not required to prove his or her innocence. The accused is not required to admit anything. The accused is not required to provide any answer to an allegation. The prosecution has to prove the accused's guilt beyond reasonable doubt. When juries are being directed in criminal trials, they are often told that the prosecution doesn't have to prove every fact that they allege beyond reasonable doubt, but they have to prove the elements of the offence. So you can imagine if you've got a case such as a case I did where a person was charged with intentionally causing serious injury. It was involving a question of road rage where an older couple were driving along and apparently annoyed another driver who stopped in front of them, got out of the car. The older driver got out and ended up being stabbed by the driver of the car that was blocking them. In that case, you can imagine there are statements which contain a whole lot of facts from the elderly couple, for example, of what happened and any other witnesses. The prosecution doesn't have to prove every of those facts, but they do have to prove the elements of the offence with which the accused is charged. So I'm going to show you a slide about theft. So this is a section of the Crimes Act 1958, section 72. Now the Crimes Act in Victoria was first brought in 1958, but it's been amended a lot of times since then, lots and lots and lots of times, making it a bit hard for judges to keep up sometimes, but it has changed a lot. The basic theft was a common law offence, but it is now defined in our Crimes Act, so it's part of legislation. And what it says is the basic definition: a person steals if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it. So I'm afraid that that property with the blue underline doesn't signify anything except there's a link to some other section in the Act. So I'm sorry that's still blue, but there you go. So that means that the prosecution has to prove beyond reasonable doubt in a theft case that the accused appropriated property belonging to another person, that the accused appropriated the property dishonestly, and that the accused appropriated the property with the intention of permanently depriving the other person of the property. And the prosecution has to prove all of those things beyond reasonable doubt. If the prosecution can't prove any one of those elements, then the accused is not guilty. So for the accused to be found guilty, the jury or the magistrate must be satisfied beyond reasonable doubt that all of those elements, all those three elements as I outlined them, have been made out beyond reasonable doubt. Now, theft is an indictable offence with a maximum penalty of 10 years imprisonment. So some offences are indictable offences and some offences are summary offences. So offences are crimes, the things that a person's charged with, what they're said to have, when they're said to have committed a crime. So there are some offences that are summary offences and some offences that are indictable offences. There are rules about whether an offence is an indictable or summary offence, and in many situations it actually says in the legislation or in the common law about the case that it is an indictable offence or a summary offence. For example, there is an assault offence in the Summary Offences Act. That's a summary offence, but there's also a common law assault, which is an indictable offence, which is a common law offence. A bit complicated, isn't it? But that happens. So that's the difference. Now, theft is an indictable offence, but you can imagine that there are all different sorts of thefts. So there can be really serious thefts of hundreds of thousands of dollars and more, or important property, but there's also going to be a lot of minor thefts, such as minor shop stealing and so forth. All that's still theft, but it's not as serious as the other sorts of theft. Summary offences are dealt with in the Magistrates Court, and they can only be dealt with in certain circumstances in the County Court. But summary offences are started and dealt with. The prosecution for summary offences is started and dealt with in the Magistrates Court. The Magistrates Court also deals with indictable offences if they are lower levelled indictable offences and if the accused person consents to summary jurisdiction. So the accused person is asked, do you consent to this court dealing with your case in the Magistrates Court? And people for minor offences will say yes, because it's not something that they want to go to a jury trial or have go to the county court for, and possibly face more serious punishment. So if it's minor offences, there are a lot of offences that are indictable where the accused consents. If the accused doesn't consent and wants to plead not guilty, then the accused has the right to go to the county court for a jury trial. Now, you can consent to jurisdiction and plead not guilty in the Magistrates Court and still have a contested hearing in the Magistrates Court. But if you want a jury trial, you can say, I don't consent to summary jurisdiction and I plead not guilty and I want to go to the county court, and you'll get a jury trial in the county court. Because people charged with indictable offences have the right to have a trial by jury. As I said, generally speaking, people don't do that. I did have one case in my experience where a man was alleged to have stolen about 100 stationery items, and he decided he wanted to go to the county court for a jury trial. It was all worth about $200. In the end, the judge said, do you really want to plead not guilty? And the man, who was by then represented by a sensible barrister, said, oh, well, maybe I will plead guilty. And the judge said, good. And then we dealt with it very swiftly. But I don't think the jury were going to be interested in hearing about him taking 20 toilet rolls and 5 writing pads and 10 pens. But generally speaking, people do agree for more minor cases to accept the summary jurisdiction. The Australian Constitution, in section 80 of the Constitution, says that anyone charged with an indictable offence under the law of the Commonwealth, so if it's a Commonwealth offence, which is indictable, then you have the right to a trial by jury. And that right, for various reasons, that right persists in the states. By and large, there are some modifications of this, but if you're charged, the principle in Victoria broadly is that if you're charged with an indictable offence, you have a right to trial by jury. The Charter of Human Rights and Responsibilities Act 2006 provides some protections for people who are going to court and for people charged with criminal offences. Now, everybody, whether they're charged with a criminal offence or they're party to a civil proceeding, has a right to a fair hearing. You remember the principles of fairness, equality and access that I mentioned before? Well, clearly a fair hearing is part of fairness. So parties have the right to have the charge or proceeding decided by a competent, independent and impartial court or tribunal after a fair and public hearing. Section 25 of the Charter, which I'm not troubling you with a slide, but Section 5 of that Charter, which is a piece of legislation, as you can see, also provides further rights and protections for people charged with criminal offences. These include several of the rights which would already exist under common law but are now incorporated in the Charter of Human Rights and Responsibilities Act, including the right to be presumed innocent until proven guilty, that you must be informed by the law enforcement agencies of what the charges are against you as quickly as possible, and that you have the right to have your conviction or sentence reviewed, that is appealed, that you can have the right to appeal. You're supposed to be informed of the charges against you in language that you can understand, and you must be given enough time and a place to prepare your defence. There is a right that says that the trial must be dealt with as quickly as possible. That really means without unreasonable delay. And you will be looking at in your study course about the impact of delay and the question about whether that has an impact on fairness and possibly access. There is a lot of delay inbuilt into the legal system. It can take at least a year and more, 2 years and so forth, for a matter to get to trial or hearing. And I think that delays have got even worse with the pandemic, and that's a problem. You've often heard the expression. You have often heard the expression, justice delayed is justice denied. So an accused person is entitled to have their matter dealt with without unreasonable delay. What's unreasonable delay in any particular circumstances is going to be, of course, a matter of debate. The main impact, from my point of view, of delay apart from the accused is, of course, on the victims of the crime and the witnesses. It must be awful to have to hang around and wait for long periods of time before you get your opportunity to present your evidence in court. It's really one of those difficult aspects, and something which I think you ought to be looking at and probably will be looking at in your Unit 3 course. You have the right to defend yourself, but of course, a lot of people can't afford their own lawyer. Lawyers are expensive. There are some mechanisms that try to deal with this, and this, of course, is about access to law in the area of crime. There's the Victoria Legal Aid, which is government funded, and there are the Victorian Community Legal Centres, which receive funding from state and federal governments. Victoria Legal Aid represents many people in the area of crime. If you go to the Magistrates Court and are charged with an offence that's being dealt with in the Magistrates Court, it is quite likely that you will be able to see a legal aid duty lawyer before you go into court, who might be able to give you some advice about what you should do. But you will not have a legal aid lawyer going into court with you to speak on your behalf unless you're at risk of going to jail. And I don't mean theoretical risk, I mean actual risk. So, for example, if you are accused with having stolen 6 packets of 6 chocolate bars from the supermarket, even though that's potentially theft and potentially 10 years imprisonment, you're not in reality going to get 10 years imprisonment. You'll be very glad to hear. You'd be likely to get a fine or a good behaviour bond or something such as that. So in that case, you would not get a lawyer going into court to speak for you. And this can be difficult because there are quite a lot of cases where people have to deal with really quite serious cases where they're short of going to jail, but they're still quite complicated, and they still would benefit, in my opinion, from someone to speak up for them. The magistrates do their best to make sure that they ask the right questions and make sure that people are treated fairly. There are a lot of people who represent themselves in criminal matters then in the magistrates' court. In the county court, that doesn't happen because almost always the cases that are going to the county court in crime are likely to attract a prison sentence if the person is found guilty. So plea hearings and trials in the county court, usually the person, well, in almost all cases, the person will have their own lawyer that they've paid for, or they will be represented by legal aid. Legal aid also represent people in some other areas, but such as family law, but I won't go into that. It's difficult because legal aid only has a certain budget and they can't help everybody. The other people who try and help are the community legal centres. There are a number of these around the state, and I had some experience myself with the Fitzroy Legal Service, which does an amazing job in trying to help people who come in having been charged with offences and various other legal problems. But again, they are under-resourced, they rely on volunteers, and they have a very hard job. They do their best, but that's one area where you could be looking at whether people really in practice have access to the legal system. Now, the rights that have been set up, I was talking to you about Section 25 of the Human Rights and Responsibilities Act and the protections it set in place. One of the protections it has is that the courts are required to provide information to you about legal aid and whether you might be qualified to get legal aid, because legal aid depends on how much property you have, how much income you have, and so forth and so on, as to whether you can access legal aid. So the courts are supposed to tell you whether you might be, whether legal aid might be available for you. All of the rights that I've been talking about so far really apply to the accused person in a criminal matter. Over the last 20 years or so, the time when I was a magistrate and a judge, there have been a lot of changes trying to provide some rights and to better treat victims of crimes. For example, there are special procedures put in place. There are special procedures put in place for people to give evidence if they're as vulnerable witnesses. So children, people with intellectual disabilities, cognitive impairments, people who just say, I can't bear the thought of going into court and giving evidence, I'll be too anxious. All of those people, so vulnerable witnesses, are able, by and large, to give evidence from a remote witness facility. They don't have to go into court. So there are special rules about that. And that provision of those facilities has made a big difference, I think, for a lot of people who are victims or vulnerable witnesses in some other way. Victims now have the right to be informed about the proceedings and about the timing of proceedings and what is going on, and about release dates for people who are convicted and sentenced to imprisonment. The other big change has been in having victim impact statements and the role of victim impact statements. So when it comes to a sentencing hearing, the prosecution go to the person who is the victim. Now, this is when there's been a plea of guilty or when there's been a finding of guilt in respect of the accused. The prosecution goes to the victim and asks them to make a victim impact statement. And in the victim impact statement, the victim sets out what the impact has been on them of this particular crime. It can be all sorts of impacts, but the particularly moving impacts, of course, are the impacts that it has on people that the crime might have had on people psychologically or physically, or in respect of their family relationships or their lives in general. The victim impact statements are often read out by the prosecutor, or they're handed up and read by the judge without somebody reading it out. But sometimes people come in, and they have the right to come into court and read out their victim impact statement themselves. And that can be a very powerful and moving experience. My personal view is that that rarely makes any difference to what the sentence would be, because generally the judge has a fairly good understanding of what the impact has been on the victim. But this is definitely assisted, because the impact the harm caused is one of the things judges have to take into account when sentencing people. But I think it's also very powerful for people to just have the ability to stand up and say to the person that has caused them harm, this is what you've done to me and my family and so forth. So that's been an interesting development. Now, when I was talking about the rights of the accused, I spoke of the right to have your sentence or your conviction reviewed. That, of course, means appeals. So the appeal system operates in Victoria in context of the court hierarchy in Victoria. So the court hierarchy is the different levels of court in Victoria. And there is a slide that I've got, thank you, that shows the court hierarchy in Victoria. So this slide shows the court hierarchy in Victoria with a very nice picture of the front of the Supreme Court. So it goes from the bottom, the Magistrates Court, the County Court, Supreme Court, Court of Appeal, and then the High Court of Australia. So if you want to appeal, if you don't like your conviction or sentence in the magistrate, you can appeal to the County Court. At the moment, you can appeal as of right. That is, you don't have to give any reason. You can just go to the County Court and say, I don't like it. And the County Court deals with it as if it never happened in the Magistrates Court effectively. That situation is supposed to change, and there is legislation on the books to say that to go to the County Court after you've been in the Magistrates Court, you have to show that there is some reason why the County Court should deal with it, that there may be something that was wrong or something in the Magistrates Court hearing, and the County Court is to consider the reasons of the magistrate and the evidence in the Magistrates Court before granting leave to appeal and dealing with the appeal. So that's been put on hold for the moment because of the pandemic, because it was decided that that might cause some extra delay in the Magistrates Court and in the County Court. But at the moment, you can go from Magistrates Court to the County Court as of right, and you get a new hearing, a hearing de novo. From the the County Court, if you don't like your sentence or conviction in the County Court, you can appeal to the Supreme Court Court of Appeal. But that means that you have to demonstrate an error of law. So to get your appeal up to the Court of Appeal, you have to show that there was an error of law. It could be an accused who's appealing, it could be a prosecution. But in either case, they have to show that there's been an error of law. And that means County Court judges have to take care when they're writing their sentencing reasons or their rulings or their decision making in the course of a trial about the admissibility of evidence and so forth, to clearly explain their reasoning so that anyone can have a look at it and see whether or not they made an error of law in their reasoning. So that slows things up a bit in the County Court by comparison to the Magistrates Court. The Supreme Court, the appeals from the Supreme Court, trials or conviction or sentences go to the Supreme Court Court of Appeal. And then if you want to go from there, you have to go to the High Court of Australia, which is a federal court, but it's the highest court for Australia. We used to have ability to appeal to courts in England and so forth, but not anymore. It's the High Court of Australia. It's the highest court in the court hierarchy. So that's the end of this talk. I hope you really enjoy your studies in Unit 3, and I hope that you will have a really good understanding of the legal system in Victoria and how it operates in both criminal and civil jurisdictions. And I wish you all the very best with Unit 3 and hopefully with Unit 4 too. Thank you.